the Act will clearly show that this suit cannot be maintained against the third defendant in the way and manner in which it is presently constituted. That by Section 2, Sub 1 of the Act, there is established a body to be known as the Medical Laboratory Science Council of Nigeria to regulate the practice of medical laboratory science. That by Section 3.1 of the Act, there is established for the council a governing board consisting of who the third defendant did not say or state. The third defendant did not bother to narrate the composition of the Medical Laboratory Science Council of Nigeria to the court in aid of the court's consideration of its application or at all. By Chief Innocent Iwuji and others versus Governor of Imo State and others, the citation is there. It is straight law that once preliminary objection to the jurisdiction of the court is raised, it is sufficient notice to the other party, since no affidavit need be filed by the objector. In Bello versus National Bank of Nigeria, it was heard that there is no mandatory requirement under the rules of the High Court for a preliminary objection to be accompanied by an affidavit, except where the party raising the objection has proceeded by way of motion on notice. In Okoli versus Ibiang, it was also heard that an objection must be based on the document already before the court, and no evidence, whether oral or documentary, shall be allowed. The preliminary objection needs not be supported by an affidavit as long as enough material is placed before the court on which it can judiciously pronounce on the objection. The third defendant submitted further in ground 3 that it is a regulatory agency which clearly defined powers and functions under the Act, that it is not an employer of members of the claimant respondents professionals as medical laboratory scientists working in the public health institutions. Functions of the board under Section 3, Sub 1 of the Act. Both appointment of registrar for the council, who shall be the chief executive and secretary to the council under Section 5, Sub 1 of the Act. The duties of the registrar under Section 6.1 of the Act, and the power of the board to make rules under Section 19. Applicant hearing, and as such, the court is urged to strike out the name of the third defendant from this suit, as to claim has been made by the claimant against it. A look at the paragraphs of the affidavit in support of the amended originating summons will show Teaching Hospital Abakaliki was established. Department of Medicine. What is this? all the departments under the medical laboratory services has always been headed by the most senior medical laboratory scientist. That ever since August 2018, the defendants collectively resolved to undermine the laws and scheme of service for medical laboratory scientists in Nigeria, approved by the federal government of Nigeria by planning to appoint and or appointing pathologists and or medical doctors and non-medical laboratory scientists to practice the medical laboratory science profession and to head all the department under medical laboratory sciences in the teaching hospital. That ever since these happenings, members of the claimant have written the third defendant to intervene and discharged their lawful duties by regulating the practice of medical laboratory science profession in Alex Ekweme Federal University Teaching Hospital, Abakaliki, but the third defendant paid a deaf ear. As a trade union, does the claimant have the locus to complain to this court about these things? My answer is a very big no. By Section 4, Sub 1 of the Medical Laboratory Science Council of Nigeria, Act number 11 of 2003, the board of the council is vested with powers to basically regulate standards of knowledge, training, production, etc., of reagents and chemicals, conduct examinations for qualifying technicians and assistants, etc. The only power of the board to appoint is that of Registrar of Council. See also Attorney General of Ondo State. This is Attorney General of the Federation. The citation is supplied. I visited the website clearhq.org on Saturday, 19th February 2022, and came across an article by Barbara Smith titled Role of a Person on the Governing Body of a Regulatory Entity. To the author, governing bodies of regulatory agencies are referred to in numerous ways in various jurisdictions. Some of the most common terms are boards and councils. The regulatory entity itself may be referred to as an agency, board, or commission. Regardless of the terms used to describe the aspects of these regulatory entities / boards and their members, and irrespective of the jurisdiction in which they exist, e.g. USA, Canada, etc., they have a number of common characteristics. Let me work. Firstly, boards are mandated to regulate the practice of a given profession / occupation or industry in the public interest. The most fundamental role for a board member is that of participating in the public interest. While different boards may use different models of governance, the basic role remains that of setting the policy direction of the regulatory body and overseeing its functioning. Secondly, boards set the standards for entry into a profession and assure the public that the practitioners offering services meet those standards. Many entities have quality assurance programs and methods of assuring that practitioners meet the standards of the profession on an ongoing basis. Thirdly, they register those who are qualified. This registration usually involves issuing a certificate or license without which a person may not practice in the jurisdiction of the regulatory body. Fourthly, boards deal with practitioners who fail to meet the standards of practice and or who are accused of misconduct incompetence, or incapacity. Board members may perform adjudicative functions in determining guilt and penalties with respect to practitioners and from an essential part and form an essential part of the system of administrative justice in a given jurisdiction. Board members serve on panels or tribunals which have the mandate to make decisions which may affect the practitioner's ability to make a living. The seriousness of these matters makes it prudent for board members to participate in their own ongoing education with respect to the of its staff at the Alex Ekweme Federal University Teaching Hospital, Abakaliki, and whose inclusion as a defendant must ostensibly be at the instance of claimant's brief to counsel, is a desirable and or necessary party. I so hold. See Green versus Green. The citation is supplied. In all, the third defendant's preliminary objection is baseless, it fails, and is hereby dismissed. Decision on the originating summons. Excuse me. I now proceed to the merit of the originating summons. In arguing against the originating summons, the first, second, fourth to eighth defendants maintain that the University Teaching Hospitals Reconstruction of Boards ETC Act 1985 that governs teaching hospitals established under the federal government in Nigeria, that from the provisions of Section 7.3 of the Act, no single paramedical professional association or body has been put in control of the day-to-day affairs of the Alex Ekweme Federal University Teaching Hospital, Abakaliki, and medical practice and other ancillary matters. That the said act has made regulations for the operations of chemical laboratory practice, especially in the field of pathology, which includes histopathology, forensic pathology, autopsy, and cytology, clinic
It's from the it's from the network. Just to I'm trying to see what is happening. He has dealt with the plenary objection I raised. Not hearing again.
You're not showing the full picture.
Hello there. It's not hearing again.
Is this showing the full picture? Well, where was I? That by section 49, sub 1 and 52, sub 1 of the National Health Act 2014, only a registered medical practitioner or dentist may remove any tissue from a living person for purposes stated in the Act. That the procedure by which this suit is brought is a complete mix-up, confusion, and misconception of the purpose of judicial review, and as such cannot be sustained. Summons by a claimant in the a critical look at the three questions raised by the claimant in the originating summons will reveal a narrow delineation of a person who is qualified of medical laboratory service in Alex Equipment Federal University Teaching Hospital, Abakaliki, or any hospital in Nigeria, having regard to the scheme of service dated 22nd February 863279/T/35, and whether by the provisions of the Medical Laboratory Science Council of Nigeria Act number 11 of 2003, the provisions of the Medical and Dental Practitioners Act number 23 of 1988 could still be construed to empower a pathologist or a medical doctor of whatever nomenclature on grade who is not a medical laboratory teaching hospital. Abakaliki. Claimant cited exhibits D, E, F, G to support its arguments. The Medical and Dental Practitioners Act number 78 of 1992 was amended by section 1 sub ability for determining the standards of knowledge and skill to be attained by persons seeking to become members of the medical or dental profession, and reviewing those standards from time to time as circumstances may permit. B, securing in accordance with the provisions of this act, the establishment and maintenance of registers of persons entitled to practice as members of the medical of those persons. C, reviewing and preparing from time to time a statement as to the code of conduct which the council considers desirable for the practice of the profession in Nigeria. D, other forms of alternative medicine, making regulation in the field of pathology, which includes histopathology, forensic pathology, autopsy and histology, clinical cytogenetics, hematology, medical microbiology, and medical parasitology, chemical pathology, clinical chemistry, immunology, and medical virology. And F, performing the other functions conferred on the council by this act. By section 3, sub 2, of the act, and any dental council of Nigeria, the council shall have power to do anything which, in its opinion, is calculated to facilitate the carrying out of the activities under the act. The claimant's contention that by section 22, sub 2 of the Medical Laboratory Council of Nigeria Act number 11 of 2003, only persons who are registered medical laboratory scientists in Nigeria can practice the medical laboratory science profession is, in my considered view, self-serving and legally unsustainable. Sections 10 and 22, sub 2 of the Act both respectively talk about a person admitted into the profession by the council, close of quote, and quote, A person who is not a member of the profession shall not practice the profession. Close of quote. Similarly, by Section 1, Sub 2B and E of the Medical and Dental Practitioners Act, number 78 of 1992, the Council is empowered to establish and maintain registers of persons entitled to practice as members of the medical and dental profession, and make regulations for the operations of clinical laboratory practice in the field of pathology, which includes histopathology, forensic pathology, chemical pathology, clinical chemistry, immunology, and medical virology. Most of this judgment, I visited two websites. That is http://jobzilla.ng and ziprecruiter.com on 18 February 2022 and made these findings. A medical laboratory technologist or clinical laboratory scientist, also known as a medical laboratory technologist or clinical laboratory scientist, is a healthcare expert who performs tests on body fluids, tissues, and cell samples to prevent diseases. A medical laboratory scientist uses sophisticated biomedical instrumentation, microscope, and computers to study samples obtained from the human body. He must qualify with a bachelor's degree in medical laboratory science and complete an internship program, a good knowledge of chemistry and biology, chemical laboratory procedures, clinical microbiology. A medical laboratory scientist can become a medical doctor by following the same education path as other aspiring doctors by attending medical school. A medical laboratory scientist works with physicians to examine patient specimen and be able to diagnose and treat disease. Attempts by the defendants to impose, employ, and permit pathologists and doctors of whatever nomenclature who are non-medical laboratory scientists, viewed in the light of the web information, by my reckoning, is delimiting, egregious, and tantamounts to cherry picking. So just like the training of a medical or dental profession dovetails into the core issue in this suit is, in the main, calling on the court to interpret the Medical and Dental Practitioners Act, number 3 of 1988, alongside the Medical Laboratory Science Council of Nigeria Act, number 11 of and suit are the incorporated trustees of the Association of Teaching Hospital, Abakaliki, the Board of Management, Alex Ekweme Federal University Teaching Hospital, Abakaliki, the Registrar / Chief Executive Officer, Medical Laboratory Science Council of Nigeria, Dr. Ahmed Tijani, the Director of Administration, Alex Ekweme Federal University Teaching Hospital, Abakaliki, Dr. Onwe Emeka Oga, Dr. Robinson Oko, Chairman, Medical Advisory Council, Alex Ekweme Teaching Hospital, Federal Teaching Hospital, Abakaliki, and Mr. Azubuike Callistus, who are all defendants. The parties in suit number NICN ABJ /284/2014 attached to the claimant's federal affidavit in response to the first, second, fourth to eighth defendant's counter affidavit, that is exhibit CS1 in this suit. In this suit are Nigeria Union of Pharmacists, Medical Technologists, and Professionals Allied to Medicine, and Incorporated Trustees of Association of Medical Laboratory Scientists of Nigeria, claimants, and Obafemi Awolowo University Teaching Hospital Complex Management Board, Mr. Vincent Ofunye, Medical Director, Central Hospital, Ughelli, Delta State, Hospitals Management Board, Delta State, Medical Laboratory Science Council of Nigeria, and Incorporated Trustees of Nigeria Union of Suit are the trustees of the defendant in suit number NICN ABJ 284/2014. As such, it is one and the same. Intrinsically, second defendant in the instant suit is a sister teaching hospital as first defendant in suit number NICN/ABJ/284/2014. The third defendant in the instant suit holds the same position for the fifth defendant in suit number NICN ABJ 284/2014. The sixth defendant in the instant suit and third defendant in suit number NICN/ABJ 284/20. Enrolled order in suit number NICN ABJ 284/2014, the court made the following orders. One, that the Medical Laboratory Science Council of Nigeria, sixth defendant, is the statutory regulator for the practice of medicine, laboratory science, and intendment of the Medical Laboratory Science Council of Nigeria, number 11 of 2003. Three, that the first plaintiff, first to fifth defendants, and or other member to and or under the statutory regulation from representing, holding themselves out, or continuing to represent and or assume any such position reserved for qualified medical laboratory scientists or otherwise interfering in the performance and discharge of the functions/duties of a medical laboratory scientist. Now, at the risk of repetition, the claimant's reliefs in the instant case as amended are: 1, a declaration that by virtue of the clear and unambiguous Science Council of Nigeria, only members of the applicant claimant profession of medical laboratory science in Alex Ekwueme Federal University Teaching Hospital, Abakaliki, and other hospitals in Nigeria. 2, declaration that the respondents, defendants, are bound by the scheme of service approved by the government of Nigeria for medical laboratory scientists to enhance efficient running and administration of medical laboratory science departments. 3, a declaration that by virtue of the Medical Laboratory Science Council of Nigeria Act number 11 of 2003 and the scheme of service for medical laboratory scientists approved by the federal government of Nigeria, the medical laboratory scientists employed in the service of the defendant respondents are entitled to autonomy of practice within their field of training and competence. 4, a declaration that by virtue of the said Act number 11 of 2003 and the scheme of service for cadre of medical laboratory scientists approved by the federal government of Nigeria, responsibility for the supervision, management, and control of medical laboratory services departments in Alex Ekwueme Federal University Hospital, Abakaliki, is placed on the director, medical laboratory services, who must be a medical laboratory scientist within the ambit of the law. 5, a declaration that pathologist or a medical doctor of whatever nomenclature or grade who are not registered as medical laboratory scientists within the meaning of Medical Laboratory Science Council of Nigeria, Act number 11 of 2003, are not entitled to practice the medical laboratory science profession via any guise or design and or head any of the departments of medical laboratory science in Alex Ekwueme Federal University Hospital, Abakaliki. Number 6, a declaration that the imposition, planned imposition, and attempt the research/advanced medical laboratory and or head members of the claimant applicant, various departments of medical laboratory services in Alex Ekwueme Federal University Hospital, Abakaliki, is arbitrary and unlawful. Seven, and in of practice of the members of applicants, claimants, and other medical laboratory scientists in Alex Ekwueme Federal University Hospital, Abakaliki, by permitting non-medical laboratory scientists, as pathologists/doctors, and persons who are not qualified, registered as medical laboratory scientists, to intermeddle or exercise supervisory function/control over medical laboratory scientists. 8, an order mandating the respondents Number 8, an order mandating the respondents defendants to comply with the scheme of service for medical laboratory scientists in Nigeria, approved by Federal Government of Nigeria on 23rd February 2001, with reference number 863279/T/35, and the laws establishing the medical laboratory science profession in the administration of Alex Ikweme Federal University Teaching Hospital, Abakaliki. It is the contention of the first, second, fourth to eighth defendants that the relevant laws were enacted to provide a uniform administrative structure for teaching hospitals under the federal government, that by the provisions of Section 7, Sub 3 of the University Teaching Hospital Reconstruction Act, no single paramedical professional association or professional body has been put in control of the day-to-day affairs of the Alex Ikweme Federal University Teaching Hospital, Abakaliki, other than second defendant. That Section 1, Sub 2, E and H of the Medical and Dental Practitioners Act, as amended, has already empowered the Medical and Dental Council of Nigeria to make regulations for the operations of clinical laboratory practice. That Section 49(1) of the National Health Act 2014 has placed the medical and dental practitioners in the position to determine the use to which tissue or blood or a blood product withdrawn from a living person will be put. In their counter affidavit in opposition to claimants originating summons, the first, second, fourth to eighth defendants averred in paragraph 34 of their deposition that the use of pathologists as heads in hospital laboratories to deal with patients' health is a standard recognized worldwide. Be that as it may, this court in suit number NICN/ABJ/284/2014 Supra held that, quote, if the medical doctor, that is pathologist, now wants to practice as a medical laboratory scientist, he must satisfy the requirements of the law and be certified by the professional body created. This court, as a labor court, has the constitutional duty to entrench the best labor practices to enhance service delivery in any industrial section in Nigeria as exposed in government's facility policies through statutes. Close of court. Section 254C1, sub F of the 1999 Constitution confers exclusive jurisdiction on this court in civil causes or matters relating to or connected. It therefore stands to reason that the practice of medical laboratory science is not the exclusive preserve of scientists, so-called, that the doors are not shut on pathologists or medical doctors or whatever nomenclature or grade to hold positions and work in the 4 departments in issue once the appropriate prerequisites are in place, and I so hold. The claimant is not in this court for the interpretation of Medical Laboratory Science Council of Nigeria Act number 11 of 2003. That was suit number NICN/ABJ/284/2014, in which the claimant was second defendant. The declaratory reliefs granted in the said suit are exponentially replicated in the instant suit, indirectly to relitigate issues that this court has already resolved. If the claimant has any problem with the enrolled orders entered in suit number NICN, its recourse is to the Court of Appeal, not this court. On the whole, it is my determination that the instant case is an attempt to relitigate issues already settled in suit number NICN ABJ 284/2014. The instant case as filed is accordingly incompetent and so is hereby struck out.
As the court pleases.
Second defendant's counterclaim. The second defendant in this suit, that is the Board of Management, Alex Ekweme Federal Teaching Hospital, Abakaliki, the Association of Medical Laboratory Scientists of Nigeria, and Medical Laboratory Science Council of Nigeria. The second defendant raised 5 declaratory and 4 orders. Against the defendants, to which she attached exhibits A to V. Second defendant also filed a written address accompanying the counterclaim, which was adopted as the second defendant's legal argument in urging the court to grant the claims sought. Order 13. Rules 1 and 2 of the National Industrial Court of Nigeria to Procedure Rules 2017 for the filing of a sought to be sued. It is well settled that a counterclaim is a separate and independent action from that in which it was raised. The counterclaimant bears the burden of proving his counterclaim by presenting substantial credible evidence. See Asipo versus Access Bank PLC, Kerry versus Alkali. See also Onochie and others versus Onochie and others. The citations are supplied in the judgment. By Moses versus Erua, citation supplied, originating summons as a process has its own peculiarities, which are geared towards expeditious determination of the course of parties, which course is not burdened by facts that are likely to be in dispute. In the case of Dapianlong versus direct. The method of commencing an action where the facts are not in dispute and where the sole principal question in issue is or like of a written law, the constitution, or other document, or other question of law. It is not a substitute for commencing contentious suits, because the appropriate method of commencing such suit is a writ of summons, in which what is alleged by the parties will be clearly defined in the pleadings, and both sides will be at liberty to lead oral evidence in proof of the averments. See Director SSS versus Agbakoba, Dean versus AG Federation, Kayamo versus House of Assembly, Lagos State, and Inakoju versus Adeleke. The citations are in the judgment. In virtue of the fact that the proceedings in the instant suit were commenced via originating summons, in which facts do not have a pride of place, cross-carpeting to a trial by a counterclaim, which trial is a product of a trial commenced by a writ of summons. It is my determination that such a suit is incompetent. Danladi versus Dangiri and others, Eze versus University of Jos, Alpha versus Atai and others, and Osai versus Wakwa and others. The citations are in the judgment. The second defendant's counterclaim in the circumstances is judgment is entered accordingly.
My Lord, my Lord, we are most grateful for the judgment. It's quite incisive. My Lord, we don't know whether we can get a soft copy into our email. Though we experienced a break in transmission in the course of the delivery. My Lord, we'll be most grateful if we can get copies, soft copies into our email so that we can digest them in full.
My Lord, we appreciate the industry put into the judgment that was just delivered. And we are most grateful for the audience. Most obliged, sir.
You're welcome. Well, the registrar of my court will handle all those things. It's not for me to handle. I have done my job by delivering.
My Lord, we quite appreciate the industry, my Lord. It was quite
That's
insightful.
okay.
Yes, my Lord.
Yeah, the court will rise.